This is Morning Cafe. My name is Stanley Nyiringite. Just a reminder for you, we're giving you live coverage of the official opening of the Bunge Towers, where President William Ruto will be there. Our reporters, Poli Kamau and Elizabeth Mutuku are there. We'll be giving you all that coverage, so stick around for that. And even as you continue, just sticking around to know what time the President will be coming in. But even as we continue, it's a Thursday, giving you tips on what you need to know concerning matters, just giving you a whole legal aid. And today we're joined by Ruth Tanui. She's an advocate of the High Court. And today's conversation is something that most families and most domestic households really come to think about it when, as an afterthought. After one of the family members, and maybe even the father, passed away, or is on the verge of, let's say, the sickbed, and this topic comes on board, the will. Oh, yes. But first off, introduce yourself kindly.
Okay. First, thank you for having me. I'm Ruth Tanui. I'm an advocate. I'm an advocate of the High Court of Kenya. I'm also the founder and managing partner of Ruth Tanui and Company Advocates. Right. Yes.
Tell us what basically is in a will, and what really is a will.
Okay, so a will basically has been, the Succession Act has defined the will as a declaration of your assets and how you'd want them to be distributed. So that's basically a simple definition of a will. Just you listing all your assets and the beneficiaries, how you want your estate to be distributed. Now when you pass on, yes, upon your death. Yes, that's the best definition of a will. And as you've said, unfortunately, most people don't consider it as a priority. Especially in African traditions, we see it as an omen, like a bad omen. By the time, it's like you're tempting fate.
It's your wishing. It's like you're wishing for it to happen.
Yeah. So when you bring it up, it's a topic that most people, it has a lot of opinions upon it. But unfortunately, like for your car, you insure your car. Of course, you don't want to have an accident, but you still go ahead to insure your car. You have health insurance because and death is something that we know. It's something that's going to happen. It's a matter of when. So that's why a will is basically you having control of how your assets that you have worked hard on can be distributed upon your death. Yes. And
largely we do have quite a number of men having the wills. And the whole conversation, the elephant in the room today would be, why is it that we're having less ladies and a few number of ladies writing these wills? I mean, you as an example, is it something that you've really thought about and say, let me write a will, by the way, and draft as from your profession? Do you get a number of ladies coming to you and saying, I'd love to write a will?
No, unfortunately, a will, I think from tradition, because a will is how you will distribute your assets, and from back then, many people, like men are the ones considered to be the ones who are supposed to write the will. But women right now, they are acquiring assets. Women have assets. Women, you might be a single parent and you'd want, in an unfortunate situation where you pass on before your kids are adults, you'd want to have a guardian, to appoint a guardian who will take care of your children. So at least you'll have that control to appoint a person who you trust, because if you don't, it's court that will appoint for you. So that's why, but most women, they're coming, a lot of women, because I've written wills for compared to men, the percentage is higher lesser for women, and not a lot of women write wills. So, and I think it's just because I don't think most people consider that it's supposed to be, especially if you're married, for instance, it's your husband is the one who's supposed to write the will. But remember, if you have acquired property, a will is how your property is supposed to be distributed. Your husband cannot write if you have, say, land that is written under your name, your husband cannot write in his will that this land should be distributed this way. It has to be you, yourself, that when you have acquired property. So women nowadays, women now are starting, I can say most women are starting now to get into writing wills. But it's still something that not a lot of women have. I don't think it's something that a lot of women have considered. But it's important, especially if you're for instance, if you're a single parent, because they're saying it's a man, but for you don't have that man, let's say, for instance, the man is not in the picture to help you to write that will. So you're the one supposed to take that responsibility.
Because right now we're having quite a number of homes that are headed by single moms.
Yes. And that's why even now it's at this time that I think it's just the way we have even started by this conversation, saying that a lot of people don't, even generally, even without putting the gender, don't consider wills as an important factor. Yeah, most people don't consider. But now, right now, it's something that someone should think about, because, you know, things happen. Death is something that we are certain it will happen. It's just a matter of when. So that's why it's something that people should actually, especially if you're a single parent, because you would want your child to live. Those are, if you have properties or even you would want your children to be taken care of by people you care about. And a will is the only way you can control that. If you don't have a will, it will be hard, because now court will have to come in. Yes.
Right. And back at home, wherever you're watching us from, you can always be part of this conversation. Call us live, and Wakili will be answering all those questions that you have concerning drafting a will. 0795045864 is the number. 22047 is the SMS number to SMS line to text us on the same. Now, for some, because you're saying for someone who's really thinking about drafting this will, what do they need to know when they come to you? They say, Wakili, help me draft this will. And they don't really know offhand all the properties that they probably have. Help us understand. Yes,
so another thing first, the Act has stipulated how it does. You may write a will, but you don't follow the law of the Kenyan laws.
Okay.
That will someone can object to it. Especially, for instance, if you have, so that's why when writing a will, you have to factor in, the first, you have to be of sound mind, because that's something that is considered. And then you have to list all your assets and all your beneficiaries, and how you would want now each beneficiary, how you'd want them to get each property, how you'd want it to be distributed. So the first thing is you have to list all your assets. The purpose of a will also is just to ensure, because some people pass on and you even don't know where some of the assets that they owned. So that's why you have to, normally we start by telling the person to list all their assets and all their beneficiaries, and how you would want them to be distributed. And then you have to also choose an executor who will execute the will. And then another important factor is it has to be witnessed by two people who are present. Like if I'm the testator, my witnesses, I have to be present while signing the will. And a beneficiary should not be a witness. But in circumstances that, a beneficiary cannot, but in situations where they become a witness, they have to also have other two witnesses to witness their signature.
Interesting. So for example, let's say it's the father, and he wants to get into the whole drafting the will. So first of all, how many of the dependents are within this will? Let's say he probably has, let's say, 3 children and 1 wife. How far can this will extend? Can it also extend to the extended family, to probably his brothers, maybe even sisters, or let's say they're also grandchildren? How far can it extend?
So that's why a will now gives you the authority to determine the people you would want to include. So you can include, like, you may find even there's a child the father adopted who's not a biological child. They can include them in the will. You may find there's a charity organization that they donate to. They might include it in the will. So the one that you can't have control over is now where you don't have a will, because court has to come in. And under the Law of Succession Act, the law considers the immediate family. That's why even writing a will now will help you to include, you have the freedom to include any person you would want. It has no control. The problem now is if you discriminate, they have said you have 3 children and maybe you put in only 2 children, you leave out 1 child.
So for example, you have this father has 3 children, and you're telling us that these 3 children cannot be the witnesses in this signing of this will.
Yeah, because they're beneficiaries.
They're beneficiaries.
Yes.
So it will need that this father bring in, let's say, maybe the aunts who are not beneficiaries to come and witness, or friends.
Yes, or most instances people draft their wills in a law firm with their lawyer. So that's why you find most of them, the witnesses will be lawyers. The lawyers now in the law firm. It has to be a party who is not a beneficiary. The party just has to be a person who is of sound mind, of an adult, but not a beneficiary. But the Act has stated that in instances where a beneficiary has signed, let's say one of the child signs the will, other 2 witnesses have to be added, not to witness now that signature.
right,
who are independent.
All right.
Yes.
So, Wakili, we spoke to a few Kenyans just to get to understand how better they grasp this whole knowledge of drafting a will and maybe the kind of questions that they may have concerning the same. Let's listen in to that as then we continue.
Okay.
Mambo ya will hapa Taita bado watu hawajazingatia sana mambo ya written will, lakini oral will, yani kujua tu niko na watoto wangapi, kama niko na shamba kwa sheria kimila lazima kila mtoto apate sehemu ya shamba, hata ikiwa kubwa ikiwa ndogo kiasi gani, lazima kila mtoto apate sehemu yake, ili kama akioa na akitaka kujenga basi awe na uhuru wa kujenga mahali pake, akingojea kurithishwa kikamilifu ili apate title deed. Lakini mashamba mengi hapa Taita title deed ziko na wazee. Hata kwangu mimi hivi sasa title deed yangu niko na, yes, lakini
wewe unayo written will?
Written will siko nayo, lakini ninapanga kuifanya.
Na mambo ya will, nafikiri siku hizi sisi wa mama, kwa sababu ya kuwa tunaambiwa tukue sawa na wanaume, na kama ni urithi turithishe sawa na wanaume, tushapata mafundisho. Na most times mila zetu zinatua sisi wasichana, kwa sababu anasema urithi ni wanaume peke yake, kwa sababu msichana si alijulikana ukikuwa unaolewa. Sasa siku hizi si wote wanaolewa, so huwa naona will ikiweko, wale wazazi huwa wanakuja wanakaa na wale watoto wao wa kike. Mimi nimesema kama ni shamba mahali fulani, nikikufa wewe ndio utarithi lile shamba, lakini hiyo hajasema na wale wengine wa kiume wakasikia.
Pengine wewe kama mama uko na yako kupanga kurithisha watoto wako.
Bio will sijaandika bado, lakini huwa tuko na ile ambayo tunasema ndio mnaitaga ni oral, ile ya kuongea tu hivi, lakini ile written kabisa bado sijaamua kabisa.
Mpango ipo?
Mpango iko. Maana
niko na wasichana 3 na kijana mmoja. Sasa mimi nikaandikisha, urithi wangu nikaandika kijana wangu, kwa sababu yeye ndio kichwa. Sasa nikaandika huyo kijana wangu, ondoo wote ni wangu, lakini sasa unajua mwanamume ndio kichwa. Sasa hiyo ndio nilifanya uamuzi wangu. Mimi nilivyo hapa na biashara yangu na watoto wangu, nilidivorce na mume wangu. So nikatafuta mahali. Kabla sijatafuta mahali, nilielezea watoto wangu mimi nikifariki leo ama kesho nisizikie kwa mume wangu, nitapelekwa mahali mtu anaweza kuniweka ama mnipeleke makaburini. So kule kungangana na watoto wangu, kijana akaniambia, ai mami, badala ya kwenda kuzikiwa makaburini, ukipata pahali ununue alafu nikuweke hapo. So nikatafuta mahali na nikatafuta uamuzi wangu. Nilipopata mahali nikatafuta uamuzi wangu, nikamwambia kijana wangu, hata nikifariki leo hapo ndo utaniweka. So hivyo ndo tu niliamua na. Lakini nikamwambia kijana, hata nikienda kwa sababu naweza enda anytime, hawa watoto usipia ni dada zako, usiwache hivi hivi. Lazima uwe kitu kimoja.
I have a written will ambayo niliachiwa na mama. Yeah.
Hiyo ni ya mama ambaye aliandika. Vipi yako wewe?
Hata mimi niko kwa mikakati, kwa sababu nilipata mfano kutoka kwake. Mimi nimetoka kwa familia ya watoto 6 na mimi ni mzaliwa wa 5. Niko na ndugu zangu wa kiume pale mbele. But sometimes according to maisha vile yako na vile unabeba mzazi, ili happen mama kaniandika mimi. Yeah. Kama next of kin. Yeah. Mimi vile ninavyojipanga, manake haki ni ya watoto wote 6. Nitawaganyia yao na mimi nipate sehemu yangu. Pia watoto wangu pia vile mfano wa mamangu uendelee pia kwa watoto. Lakini ni muhimu sana mtu kuwa na wili yake. Yeah. Ile wili tuliyoachiwa na mama iko na jina.
That is what Kenyans are saying. What are you seeing out there? 0795-045-864 is the number to call us live and ask all those questions regarding drafting a will. From matters drafting a will, when we started, I had informed you that we'll be crossing over to Bunge Towers, but not now, but in a few. President William Ruto, being told, has arrived. He will be unveiling the Bunge Towers, and we'll be telling you more details on that. We'll be giving you more coverage. Elizabeth Mutuku as well as Apollo Kamau are there. Right now, though, let's go. All right, I'm being told that actually let's cross over and listen in briefly to what is happening. Vox Pops and just listening to what people are saying, men as well as women, on the same and different issues arose here, as matters divorce and the oral bits. And I'd love you to tell us more about this.
Okay.
The kind of conditions. Can I actually say that mimi niko na watoto watatu na wewe utachukua hii, wewe utachukua hii, and that's done?
Yes, and you can do either an oral or a written will, but an oral will has conditions, just like the written will. For an oral will, it has to be at least have been made 3 months, at least 3 months prior to your death. But for there's an exemption for military officers.
I mean that's interesting. Before you actually get into the exemption, 3 months prior to your death.
Like at least minimum. At least. Yeah. So you might have made it 5 years ago, but at least it has to be the minimum 3 months.
So that's like telling a human being you should have known your death should be at this time and plan it prior.
No, I don't think, that's not what I'm trying to mean. It has to be, if, let's say, for instance, I make an oral will today, God forbid, then you pass on a week later, that wouldn't, it has to be made at least 3 months. The minimum will be 3 months. So you'd have made it even 5 years ago, 1 year ago, but the minimum is 3 months.
Do you feel like that's a bit unfair? If I started to plan for it right now, and then I pass away again, God forbid, before the 3 months hit, so it becomes null and void? Yeah, it becomes null and void, unless you are a KDF officer, military officer, who is on the line of duty. Do you feel like they're the only ones who are exempted? Do you feel like that's a bit unfair when it comes to the Constitution? I think it's because of the factors they consider. They consider you have to be of mental stability while doing the will. So it's considered if you're doing a will out of circumstances, you may not be doing it you may not be very sober while doing it. Yeah. Like for instance, right now, if maybe you're told people are being shot out there, and then for you, you're like, this is the time I should. You see now that one is not considered mentally you aren't sound while making it. Yes. All right. I think that's I'm just giving an assumption. I think that's something that they have considered. It was considered, yes. Interesting. Okay, so be it as it may, I'm pretty sure some would feel it's a little maybe unfair on the same bit, something that many people actually may not know. But then still on the whole oral bit of it, I'd love to know, so I have said that I have, let's say, 3 children, and child A gets this just orally. Years later, how does my oral statement is proved in a court of law? Yeah, because now that's another requirement. Apart from the 3 months, it's supposed to be 2 witnesses. So that's the purpose of the 2 witnesses. Because even the law normally states, like for instance, now me and you, we are witnessing a will for person X. Then now we are now the witnesses. We are the ones now who will confirm what the person X said. So we'll say now this person said the property in Kantafu goes to child number 1. We are the ones now who will enforce it. So even sometimes, even when there's disagreement, for you felt he said no, it will go to child number 2. It will just be invalidated to that extent. The rest, which both of you are in agreement with as the witnesses, it will be enforced. One of the ladies from Taita Taveta said, well, she already said that my elder son is the one who's going to get a property, this particular property. So does that again mean, because when you started you're saying you've witnessed a few ladies coming to you to actually draft the will. So does it mean now that for most of these ladies, they prefer to do, or rather they're actually doing oral wills rather than the written ones? Yeah. I think that, but not even before we go to that, I've noticed something she said. She said she has 3 children, 1 male and 2 females, and she said she only wrote
bequeathed her property to the male, child. First, that is discrimination. It's not allowed. You can't, that's how I've told, I said you can't discriminate, because you know what happens if you have written a will, it doesn't mean that you don't go to court. You have to go to, you apply for grant, it's called grant of probate, just to enforce it. You'll just go per the person's will, but it has to be enforced. Then it's gazetted for 30 days. So the two daughters can object it. And court, the moment they know you are one of the dependents, now you're the daughters, you prove that to court. Court will, it will vary the will. You can't, that's even the first place you should start. You can't, while writing the will, you can't discriminate some of your dependents.
There's something you've said, so after she's done, now a huge advice even for her. So she's done it orally, and she said, my elder son is going to get it, and I'm bequeathing my property to the elder son. So how do you actually now solidify this oral statement that you said, despite the fact that there are actually two other witnesses? There's something you've mentioned, a whole act of the gazettement or the same.
Yes.
Tell us about that.
Yeah, because you have to apply for, it's normally, it's called grant of probate. You apply to court. Stating if it's a written will, you attach the will. You say this person passed on, the appointed person X as the executor. So it's gazetted, just for anyone who is opposing it. The same thing now, even for the oral will, it's the same thing. You'll apply, and then the two witnesses will put in a sworn-in affidavit stating what the deceased, the person who was passed on, stated. So now after now it's put on Kenya Gazette, it normally runs for 30 days. So when it's put...
Both written and oral?
For both, yeah, for both.
Okay.
Yeah, it runs for 30 days. And then if you're objecting it, you can make an objection in court. You file an objection objecting the will because it's discriminatory. You're a dependent and you're not included. Court looks at it. So of course you bring proof, birth certificate to show that this was your mother. Like for instance, the one now, and you aren't included in the will. Court will vary the terms of the will to ensure you have included all your dependents.
Right. So in the 30 days, for example, because we had a hypothetical of a father, he has 3 children and a wife. So these 3 children, one of them maybe was left out, or maybe was actually included. Let's use as hypothetical. So he or she was included, but then he or she feels like I don't want your will. I don't want to be part of to be a beneficiary. Can that be a ground to have this person go to court and say, I don't want to be part of this will? Yeah,
you can still do an objection on the grounds that you don't want to be part of the will. Yeah, because that's the purpose of being gazetted. Then now you make, with court, you make any objection, and then the court now will make a decision based and hear you out. What is your reason for objecting? And then the other party also weighs in, and then court makes a decision. Yes.
Right. So, for example, a couple got married, and let's say after 3 years of their marriage, they, both of them either, decided to write a will. And you'll also be telling us how, again, that works if the mom and also the father, write separate wills. And they live, let's say, for the next 20 years, and they still have that will that they had 20 years back. What happens? Is this will supposed to be updated regularly? Because it will be assumed that for the 20 years, they'll have amassed quite a number of property that they didn't indicate 20 years back.
Yes, that's why you started by asking what should someone know when they want to write a will.
Yeah.
The important thing, that's why we normally advise use an advocate, because the advocate will ensure you incorporate everything that you're legally required. So one of the things that you're legally required is to regularly update your will. Well, even you may find your executor, the person you appointed, maybe, God forbid, passes on even before you. Let's say you'll have to amend your will to include, you appoint another executor. Or maybe they have said you start acquiring other properties, or even maybe when you're writing, maybe you had 2 kids and now you have 4 kids. So you have to always update your will. It's advised you always update your will. But not for instance...
After how long?
Like when circumstances change. Now, for instance, if you acquire a new property, you change it. Maybe you adopt a child and you feel this person should be part of your will. You can update. It's regular. When something changes and you feel this should be included in your will.
So, for example, this couple had, let's say, for the 20 years, and they updated it until, let's say, the 15th year. But then they have not. It hasn't been updated for the past 5 years. When it is before the court. Will the court be looking at the latest, or rather the will that is at the moment, the one that was updated, let's say, 5 years ago, and in the 5 years, that since it was last updated, let's say there were property that was accrued, maybe a child was adopted and all that, circumstances arose. What will happen in such a kind of a
Where
case?
circumstances arose, but it wasn't included in the will.
Yes.
Because now you see, now let's say these couples have passed on. Now, of course, now the family, they'll try now and go and you apply for grant of probate for the validity of the will. So now the people who weren't included can now object it. Remember, the only way court maybe can come in is now after it has been taken to court, when someone has applied for grant of probate and once, because the normal circumstances you find, of course, the ones who are benefiting from that will want it to be executed the way it is. And then now, of course, the people now who are not included, and they can object to it. And then court now will vary it accordingly. Sadly, even we have situations where, even there's a case I know about, like you go to, Kenya Gazette is placed and you don't object. It is assumed no one has objected, because you can't claim ignorance in court. You can't say that I didn't see the Kenya Gazette, I didn't know they put Kenya Gazette every Friday. So you can't use that as an excuse. So there have even been instances where someone will, then now you come later on. That's when you find someone going to argue in court that they placed the Kenya Gazette, no one objected, so they have no ground of coming to object it at this point. But now, of course, if there's issues of fraud, court, of course, will reconsider it. Yes, so, and that's why it's just up to now the parties. Now, if the one that was written 20 years ago, if you go and the people who benefited, if they go to court and annex it and no one objects it, so it will mean now the other parties might object, or if for them, they would want but now that the will be invalidated, because now they can't, it has to be invalidated, now it will become the person died intestate without a will.
Okay.
Yes.
Does also divorce apply to the circumstances that you're telling us? For example, this couple that I had given a hypothetical, they got married 20 years ago. But then, now let's say they didn't actually reach the 20 years. They live, let's say for 10 years, and then they got a divorce. Before they got a divorce, they had already written a will, either of them or maybe both of them. Yeah. So what happens in such kind of a case?
It's the same thing. If you don't update your will and you're divorced, the terms of your will are abided by. So if you didn't amend your will, the same thing happens. You have to, now the current wife, let's say the person remarried, or they can come and object it on those grounds. And then now court will hear them out. You can object now the will. The written will is stating that by the time this person had already divorced, you bring evidence to court, then court is now going to make a decision. Yes, it's the same thing. You have to just apply then an objection. When now it's when the person has applied for grant of probate, then the gazette is made. 30 days, you object it.
Right. On Facebook, Macau XOX asks, what if I leave out some of my property on the will?
Now, unfortunately, now that if you've left it and no one objects the validity of the will, now that's the situation where now your property will just, and let's say, for instance, none of your dependents know about it. That's now a situation where now nothing can be done. We have had situations by there where you find someone knows, when the person passes on, this person, maybe let's say for example, didn't have a will, but this person, my father had property in, let's say, Mavoko, but you don't know exactly where the property is. So that's why writing a will, you have to be specific. And if you leave out, it's to your own detriment as now the testator, the author of the will. Because now your properties, unless no other dependents knew about it, now by that one now will be dealt with intestate, because it wasn't included in the will. So administrators will be appointed by court.
Ah, okay.
Because with the will, you have the power to appoint an executor who you trust. But now if you don't have a will, administrators are appointed by court. Yes.
So far in your experience, what are some of the common mistakes that people oftenly make when it comes to drafting a will?
Yeah, the first one even is the one we have just talked about. They don't update their wills.
Yeah.
You don't update your will, and then others, they don't get legal advice. So for instance, if a will is not written, then we have said you have to have two witnesses who are not beneficiaries, and if they are beneficiaries, there has to be another two people who witness that signature. So people make that mistake, and the moment now, if you write a will right now and it's witnessed by one person, that will, it's like you're just the same as the person who didn't write a will. Now it's invalidated, and then your estate is dealt with intestate. You died as though you didn't write a will. You didn't die testate. So that's one of the, and then the one I've said, not getting legal advice. And then the other thing is leaving out properties, some properties. Those are some of the mistakes someone makes. Now, the moment you leave out, now you see that one now will be, I think it will now be up to fate. Because then if you left it out, the only ones that can be dealt with are the ones that you listed in your will. Yeah, so it will be to your own detriment if there are properties that you didn't include in the will. And then the other mistake people make is leaving out some beneficiaries, some dependents, and now that invalidates the will. And then now the other thing also is now the one, like now for the oral will, you have to make sure, you know, even from what we were watching, it's like they just said, that's what we have been saying. They have not specified specific people we have told about our oral will. You know, you can't just, now you see now it will be hard for it to know even which witnesses had about the two, were there two witnesses, were there, you know.
So and what happens if it's a dispute in court and the two witnesses who are there at that time, you know, passed away probably? So that goes again to, they had to have signed the affidavit of they actually had you.
Yeah, they have to swear an affidavit now stating what they had you and what now they had you said about your distribution of your estate. So if the person passes on now, it's the same thing as a written will. Now it becomes, and if you didn't tell, maybe you didn't now maybe include another witness. Now that becomes now it should be invalidated.
One of the most important questions people will be asking right now is, I don't probably even have a job at the moment and all that. When should I, and probably I've just gotten married, it's a year plus. When is the right time though to start writing a will? Should you start thinking about writing a will when you have a family, or you know, someone as single as they are, mtu ni bachelor pale nje, can they even start thinking about writing a will? They don't have children at the moment. They don't really have beneficiaries at the moment as well. Should they also be thinking about this?
Yeah, I think they can just be maybe considering it, maybe looking at, but now you know the will, the way we have defined it at the beginning, it's you as like assigning your assets to beneficiaries, like your assets and how they are going to, how your estate will be distributed. So I think it will be hard if you don't have the assets to, but now I normally say, like, even if you know, it doesn't have to be only assets, even if you have kids, remember your kids might, God forbid you pass on, they have said when they're still minors, you'd want to have a guardian appointed. So you can have a will. Now, I think when the moment you have property, and also the moment now you have children, dependents, you have children, and you'd want now to be in control of who is going to be the guardian of your children, so that you don't leave the fate to court. Yes.
Do some people also write how the instructions of how the funeral should be and all that? Is it also included in the will?
Yes, it's included in the will. Like even someone like Nicholas Biwott, he even allocated some funds for the maintenance of his grave.
Wow.
Even the one for Ogola.
Oh,
I think he had said for him he wanted to be, there's instructions he gave.
The instructions given.
Yes, that's even the benefits of now a will. You'll state how you'd want to be. That's even one of the things that is included in the will, because you also write how you'd want to, like your funeral to be undertaken. There's one I know, they said they want people to wear white, and they didn't want it to go past 12, people should go back to work. It's a person who really loved. So you can have that control. But now the problem is, they normally say a dead body doesn't have rights under the law.
Yeah.
So like, if people don't, now that will be now it will just be, you'll be depending now on the people you trust to do what you stated.
What is instructed. So are there instances where even before the passing, someone can actually come and protest and say, you had written this on your will, let's say it's some funeral instructions, but then we as a family, we feel we can't really do that. Can that be in a court dispute?
Yeah, but no, they have said a dead body, when a person has already passed on.
No, like before they actually pass.
No one can, you know, the will, it's you who has the power at that time. No one can, like you give the instruction of how you want your property. Remember, you're not dealing with anyone's, it's never you're writing a will, you're working with your money, your assets. So and a third party cannot have, you know, right now, if maybe you want for you, from your estate, the money, your own money, you want to be buried in a certain way. You know, the other party can't have control. You're not using their money, you're not using their resources, it's your resources that you're using. Yeah. So during when the person is still alive, there's no way, because now that person even is there to state exactly what they want. The problem normally comes in when this person has already passed on, now when executing the will. But now they have said like the property, like now for Nicholas Biwott, the way for him, he said you want it to be maintained. If for instance they don't actually do it, there's nothing that much that can happen. Yes. Because now it's the property, like when you're passed on, you're no longer, like you don't have rights.
Right.
Yes.
Now for the executor, what should I need to know when I'm selecting an executor?
Yes, so you'll have to look for someone you trust. Because remember, even though you're going to apply for grants of probate, it's just to formalize. But everything that is written in the will it's done the way it is. So the executor should be someone first, even who is of sound mind, a person you trust, whom you know will be able to execute whatever you have written in your will. Most people by there, they normally choose maybe a lawyer, because it has to be like an independent party to execute your property. So that's why you find when someone has passed on, the entire family comes to then now they read out what the deceased wanted for the property. So the executor should be, that's now the thing, that's the most important thing why even write a will, because you choose a person you trust. It has to be a person you trust, because you want that person to execute exactly what you have written. Even for instance now the burial, because someone might say I want to be buried standing.
Oh,
like,
yes.
Maybe, and there's the reasons why you have written that. So you want someone who will actually honor what you want.
So is there communication between the beneficiaries and the executor even before this will is well drafted? And actually all parties, at what amount of say does the beneficiary have when it comes to what is on the will?
Nothing. I think it normally comes in after now the person has. Most people even do. You may find even like your father has a will, but you don't know. Has a will, but you don't know about it. So it's after now that you don't know, or maybe you know he has a will, but you don't know the contents of the will. Like as a testator, the one drafting the will, you're not obligated. You may decide to tell like your family, your children, I'm going to do this and this, so they might be aware. But you're not obligated for them to chip in. Okay. It's not, because it's you. Basically, it's your property. It's your. It's everything is yours. So you unless you just want them to chip in, but you're not obligated to ask for their opinions.
So it would be just a personal, view on someone's own volition to say, well, this is how the will looks like as a beneficiary. What do you think? And all that. Yeah,
it's just because maybe your father may decide to call all of you and be like, I'm doing this and this, but they're not obligated. As a testator, you have all the control, and that's the point of a will. At least you'll have control of deciding. Because sometimes when you say the disadvantage of not doing a will, you may find it will be you leave it on the fate of the court, and court looks at immediate family, and maybe for you there is a property that maybe maybe son X will not take care of that property.
Yeah.
It may dispose of immediately. So in a will, at least you have an opportunity of making sure your assets are distributed to how you would want for it. Because I normally say it's something you worked hard on.
Oh, yes.
That's why it's something you have to consider. Like it's something like even though you have passed on, at least have control of how you are. Like you've seen these very big families, there have been disputes. Like these big families, they're the ones that get to the media. The ones who have wealth, but there's no will that was written. So they spend years and years in court disputes. Because of lack, there was no will that was drafted. So it makes things even harder. Even it makes it hard for your dependents or your family when you've passed on. Because now you leave them just battling.
Disputes and disputes.
Yeah, in and out, they're in court. And these cases take, because someone files an objection. Someone files an application objecting. So it takes a lot of time in court.
Before getting to the gaps, and it's a question that a lot of people ask there. If you have in a polygamous marriage and the couple of families that you have, let's say it's a man, can you have a number of wills, or does it have to be only one and you list every single thing down, all your beneficiaries down, or can you have let's say 2 or maybe even 3 wills and they say this is going to be splitted?
No, you can only have one will, and the moment you have another will, you have to revoke the other one.
Okay.
For instance, you have said maybe someone wrote a will 20 years ago. Yeah. The moment you write another will, no, maybe in 2024 you want to write another will, you have to state in that will that you have already revoked the other will, the one you wrote 20 years ago. Yes, because the moment there are 2 wills, it will be invalidated.
All right.
Yeah, it has to be one will.
Are there any gaps? Are there any gaps you feel like there are there any gaps according to you in the Succession Act?
Yeah, I feel, because even the part where, like, if the will is invalidated, the act only focuses on immediate family. It has to be immediate family. It focuses on immediate family. But sometimes we find this person who passed on had adopted some children, had some children home that they were taking care of. Yeah, so now that becomes, I feel that is a gap that it can be solved, because now you see that these people who are dependent on this deceased person will not benefit from it. But anyway, someone can argue it has been solved by ensuring you write a will. But now sometimes circumstances can happen, or maybe even your will can be invalidated. Yes, I think that's one of the gap I feel it's there when it comes to will. And I think it can be expounded on the issue of, for instance, like now the oral will. I think it has, for the oral will, I think the one you're talking about, the 3-month thing, it can be considered. For some people might argue it's unfair.
Oh, yes. I included.
Yeah, someone can argue that it's unfair, but I think that's one of the other gaps that I see when it comes to drafting of wills. And then the other thing now, but that one doesn't involve the Law of Succession Act, but it's just the lack of knowledge people have out there in regards to wills.
Oh yes, I mean, even after listening to the ladies and gentlemen from Taita Taveta and what they have to say, and that really takes me to my next question. What should people out there know when it comes to, and mostly particularly even for the ladies, what should they really know when it comes to drafting a will? Yeah, so both orally as well as written.
Yeah, so the first thing, of course, you don't want your will to be invalidated, so you must know the factors. Like when writing the will, make sure at least you're of sound mind. Like for instance, if you write a will, if maybe you are undergoing depression, when the moment medical documents are brought in, that you wrote this will and you're not of sound mind, so make sure. And then another thing you have to make sure is don't discriminate in your will. But I would advise but not some might be, for someone find it biased, get a lawyer. Okay. Get a lawyer to help you writing the will, so the lawyer can ensure that. So that at least, because the lawyer will ensure that you have all your assets listed, you have all your beneficiaries, the name of your beneficiaries, and also the beneficiaries also you have, because family members have similar names. So they normally said that you have to state all their names, so that at least they know that, especially I think it's the Kikuyu culture where you are named after, I think, your father, you get exactly the name of so at least you have to be very specific in your will, while putting your will, listing your assets and the people who are supposed to benefit from it, and then make sure it's well attested to the witnesses, the executor, and make sure if you're updating it, and if you write another will, you revoke the other one automatically. So that it becomes, this is my last will and testament. That's why when you write the statement, this is my last will and testament. Yes.
Someone would ask for the property. You have listed, let's say, 5 properties. One of them is contested in the court, or maybe has an ongoing dispute. Should you also write that?
No, but normally, if let's say that property has an issue, it doesn't invalidate the will. So everything else will stay as it is. Then that one now, it will now, maybe if it has an issue in court, it will be solved. Then after it's solved, now it will still be effected now as per the will. Let's say if that property was going to son X. Yeah, it doesn't, if there's an issue, it doesn't invalidate the entire will. Yeah, because we find some people, the common one is maybe that property doesn't have a title deed. Or yet, like the property belongs to the deceased, but it doesn't have a title deed yet. So that will not invalidate the will. Yes.
Right. Your final thoughts as we also take a short break and wrap up this conversation.
So I think what I would advise people is consider having a will for you, so that at least a will is basically a control. You can have control over your assets. Even for people, you don't have to be rich, wealthy. People assume it's for the wealthy, because now someone is like, I don't have property. But even if you have children, it will give you control on how your kids will be taken care of. So that at least you can appoint guardians that you trust. You don't leave it to the masses, maybe of your relatives or court, for it to be determined. So my advice is people should consider writing wills, and you can seek advice from your lawyer on the procedures of writing the will.
Right.
Yes.
Thank you very much, Ruth Chanui, an advocate of the High Court. That has been the legal tips that you need to know. You've written down all those wise nuggets of wisdom just to understand how do you draft a will. And that is why we put a pause on this conversation. It continues on our digital platforms. Do you know what you need to have when it comes to drafting a will on the same? We're taking a short break. Remember, giving you live coverage on the the official unveiling of the Bunge Towers. We'll be giving you all that in a few. Stick around right here at Morning Cafe.